Welcome everybody to our monthly Money Life webinar. I'm Jim Allen, President and Chief Financial Planner here at Anchor Bay. So a little housekeeping. This presentation will be recorded and we'll post it to our website at some point in the next couple of weeks. If someone could give me a thumbs up that they can hear me okay and they can see the screen. All right, looks like we're good to go. So let me pull up the presentation. Okay. Can you see the estate planning slides? Let me thumbs up. Okay, great. All righty. I can't see them and see the interaction. Okay, so what we're going to talk about tonight is probably one of our most popular webinars, setting up your estate plan for success. And so I'm going to pretty much talk about what documents do you need? Why do you need them? What's the purpose of a living trust? Kind of how taxes work when someone passes away. So pretty much everything you need to know about your estate plan. And this is one area where we see a lot of people coming in that haven't really dealt with this yet. Couple reasons: it's a difficult topic, and maybe there's disagreements within the family about what to do, so nothing gets done. Or it's they don't want to incur the cost of going to an attorney and get documents drafted. And the other thing we see, one of the common mistakes, as we'll talk about, is they did a plan maybe when they first had children and it's never been touched since. So we're going to talk about what you need to have in your estate plan and some of the common mistakes to avoid. So just to kind of start, when we talk about the estate, what we're really talking about is all of your stuff. So this is your personal property, your cars, your jewelry, all of that kind of stuff. It's your IRAs, your 401ks, it's your stocks and your rental real estate and life insurance, it's businesses, your home. Everything is part of your estate, and it goes into this funnel, which may be just an actual estate that's going to be managed through a will, or it may be a living trust, or it may be a combination of both of those. And so, everything funnels in. You're going to have someone who's going to settle the estate for you, whether that's an executor or a trustee, or sometimes both. And from that funnel, you have to make final payments. So you've got to pay, pay off all the claims of your creditors, and you got to pay final expenses. And if not done properly, you have to pay probate fees and attorney fees and executor fees and all of those kind of things. You're going to have to pay an accountant to do final accountings, all of that. So, that's the whole state. And so you start with everything you own. From there, you start subtracting all these final expenses and final taxes. What you have left over goes down to your heirs, so whoever you designate. And as we'll talk about, there's lots of different ways the money can get through that funnel and down to your heirs. So it could be through a beneficiary designation. It could be through a trust. It could be through a will. It could be title. Or if you don't have any of the above, then the state determines who gets it. So we're going to talk about all this in more detail. So how assets are passed at death. As I just mentioned, there's lots of ways this occurs. For most people, a lot of it is through beneficiary designation. If you have a 401k at work, or if you have IRAs or Roth IRAs, or you own life insurance, all of those have a beneficiary. And so the beneficiary dictates who's going to get those assets. So they don't go through your trust, or they don't go through your will or anything. They pass directly via the beneficiary designation. The next way, which is pretty common if you own a home and you're married, you probably own it joint tenants with right of survivorship, which means first spouse passes away, the second spouse inherits it. And there's nothing that gets changed until the second death. Another way where you can have a transfer on title is what's called a TOD, or transfer on death account. And so you may have an investment account, but they technically don't have beneficiaries, but they do have these TOD features where you can name someone who would inherit that brokerage account when you pass away. And so we'll talk about both of those methods avoid probate. Next is via your will. So things that aren't going to pass via beneficiary or title are going to pass through your will, and they become part of the probate process. So we'll talk about that in just a sec. And so the will may just say executor is going to do various things with all of the property, or the will may say we're going to set up a trust at my death. Everything goes into the trust, and then the trust distributes all of the assets. And then finally, you've got revocable and irrevocable trusts. So the most common is the revocable living trust. We'll talk about in great detail. There are situations where maybe irrevocable trusts are going to be involved. And then finally, as I mentioned, you have something called intestacy. So if you don't have any of these other methods set up, then the state determines who's going to get what. Let me just do a quick check-in and make sure that you guys can still see the slides okay. I can't view the comment section and the thing. Okay, so it looks like we're still good to go. All righty. Okay, so let's talk about taxes. So I think it was Benjamin Franklin said the only two sure things in life are death and taxes. So we're talking about both of those in this webinar. So essentially, there are two potential tax systems in play when someone passes away. The main one, and the one we're going to spend most of the time on, is the income tax. And so you have tax on retirement plans, what's called income in respect of a decedent. You have this really nice feature called a stepped-up cost basis, and we'll talk about that. When someone passes away, they're going to have a final tax return, but then also, depending on whether they have a trust or whether they just have an estate, there's entity returns that are going to have to be filed, Form 1041. So if you have a revocable living trust and you pass away, it now becomes irrevocable, and it has to file an income tax return. Or if you don't have a trust, you pass away and you have a probate estate, then the estate has to file a tax return. So we're going to talk more on the next slide about income tax. The next one, and this is one we get a lot of questions about, but honestly, it doesn't apply to many people anymore, estate inheritance taxes. And so, I spent 20 plus years of my career focusing on estate planning and estate taxes. Some of you may remember back, in the 90s, the estate tax exemption was $600,000. So a lot of people had to worry about the estate tax. The current exemption, as it sits right now, is just under $14 million per person. So if you're a married couple, unless you're worth more than $28 million, you don't need to worry about the estate tax. And so all of that super sophisticated planning myself and my team used to do for entertainers and athletes and executives and all that, it's not applicable to most people anymore. Also, fortunately, there is no inheritance tax in California. Other states do have an inheritance tax. For example, Washington, their threshold's not $14 million, it's $2 million. So there could be situations where maybe you don't have to pay federal estate tax, but you may have to pay state estate tax. As it's just right now, with the exemptions this high, 99.99% of the population don't have to pay estate tax. Now, this may change, as we'll talk about. So if you have estate taxes, the tax rate is 40% of the taxable estate. And the way it works is, again, that funnel, all of those assets at the top, that's your taxable, that's your estate. Then you're going to subtract out anything you give to charity. You're going to subtract out anything you give your spouse if you're married. And then finally, you're going to subtract that $14 million exemption. If after all of those subtractions, you have something left to be taxed, you're going to pay tax at 40%. You also have something that we use fairly frequently, though, again, it's not necessarily that important with the exemption that high. You have a $19,000 annual gift exemption that you can give 19,000 to as many people as you want each year, and it's indexed. It just went from 18 to 19, and you don't have to worry about using any of your exemption or anything else. It's what's called the annual gift exclusion. So what potentially will happen with the estate tax, and this is something that's been talked about for the last several years, is the current tax act, the Tax Cuts and Jobs Act, essentially doubled the exemption from, at the time, 5 million index for inflation. And so now with the indexing, it's $14 million. If nothing happens this year, that exemption will sunset and we'll go back to the old one, which means you'd still have roughly a $7 million per person exemption. So, now instead of having to worry about estate tax at 28 million, you'd have to worry about it at 14 million if you're a married couple. This probably isn't going to happen. We think that the current Congress, in the makeup of it, they'll want to, at a minimum, extend the Tax Cuts and Jobs Act or kick the can down the road to deal with it at a later date. So we don't think we need to do any kind of urgent planning around estate taxes at this point. Though last year, when we didn't know exactly what the makeup of Congress is going to be, we were starting to consider, hey, what are we going to need to do for our clients in terms of the estate tax? For most people, it's a non-issue. But what for most people is an issue are income taxes at death. And so income tax treatment is going to vary depending on what the asset is. For example, retirement plans, retirement plans, your 401ks, your IRAs, you haven't paid tax until you've taken it out. So if you die with money still in there, the government wants to collect their tax. And so you have something called income irrespective of decedent. So when money's taken out of an IRA or a 401k at death, whoever receives it, the beneficiary, pays the income tax. Now, if you're under 59 and a half, the beneficiary is under 59 and a half because they inherited it, that 10% penalty goes away. But the income tax will not go away. They're going to collect it from somebody. They didn't collect it from the participant, so they're going to collect it from the beneficiaries. In addition, there's a recent rule over the last several years where before, if you inherited an IRA, you could essentially take distributions over your life expectancy and spread that money out, what we call the stretch IRA. They've changed those rules. So essentially, if you're a non-spouse and you inherit an IRA, you're going to have to essentially clean out that IRA in no more than 10 years. So you can still potentially stretch it out over a 10-year period, but that's as far as you can go. Now, if you're a married couple and one of you passes, your spouse can roll it to their own IRA and avoid the tax until they take it out. And then finally, if you have Roth IRAs, and this is one of the big reasons we really try and promote Roth IRAs, they're non-taxable. So you have $1 million in a Roth IRA and you pass away, your beneficiaries can take that money out tax-free. And they can spread it out over those 10 years, but all the distributions are going to be tax-free. So Roth IRAs are very beneficial as an estate planning tool. Now, if you have non-retirement plan assets, the biggies, typically your home, or maybe brokerage accounts, or CDs, or whatever they are, those assets get what's called a stepped-up cost basis. So the value from a tax standpoint gets increased from the value that the deceased paid for that asset up to the value on the date of death. And so you only have capital gains on the increase after the value after the date of death. So let me show you an example. So let's say mom bought a house for $150,000 and now it's worth $750,000. So if mom sold it, she's going to have capital gains tax on $600,000. You do have a $500,000 exclusion. So she technically, she would only have a $250,000 exclusion. We're not going to single person. So she would pay tax on $350,000. However, if she holds that house until she passes away, and son inherits it. Son's base is not the 150, it's now the 750. And so let's say son sells it a year later for 825, his capital gains is only on $75,000. So we avoided $600,000 of capital gains. This is an area where we see mistakes being made quite a bit, particularly for elderly clients who, they bought their house 50, 60 years ago. They have virtually no cost basis in it. And if they're going to sell it because they're moving into independent living or assisted living or something like that. We really want to evaluate whether that makes the most sense. Is there a way we could just hang on to that asset until one of the spouses passes away, so we can get that stepped up cost basis and avoid the tax? So that can be a mistake that people made, is like, okay, mom and dad are moving out of this house, let's sell it. Maybe not. If they're in their 90s and their health isn't good, let's see how we can just keep that house until they actually pass, or the first one passes, and we can avoid all that capital gains tax. So let's talk about California property tax, because this is a biggie. Some of you may have, Prop 13 tax base where you don't pay tax on all of your property tax base. So what you have with this new Prop 19 from a couple years ago is you can now carry over that Prop 13 tax base over to another property if you move. If you're over 55, you can do it up to 3 times. Also, with all the fires that we've had in the last several years, so even if you're under 55, but your house burned down because of one of these horrible fires, you could take advantage of that Prop 13 base as well. So this has been effective for the last almost 4 years. And the other biggie when it comes to estate planning is you can transfer that property tax base to an heir. But there is a couple caveats here. It's only for your personal residence, so it's not going to apply to rental property or anything. And the only way you get to carry over that Prop 13 tax base is if the child lives in the home. So if you want to pass down your home to one of your children, and there's some other restrictions, like the cap is, I believe, $750,000 before you'd have to start paying some additional tax. But if you want to pass it down to one of your children and they want to live in that house, you can carry over your Prop 13 property tax base, which obviously saves a ton of property tax. Okay, so that's taxation. Now let's talk about the estate planning documents that virtually everybody should have. And so we'll kind of go through these in detail about what they are, what they do, why you should have them, etc. So there are essentially 3 documents that every adult should have. They should have a will, they should have a financial power of attorney, and they should have a healthcare directive. So if you have kids and they're now 18 years old, and they have to go into the hospital, and they can't make the decisions for themselves, just because you're their parent doesn't mean you're going to be able to make any decisions. Without that healthcare directive, you're going to be stuck. Same with a financial power of attorney. Let's say there's an accident and they go into a coma or something like that. You can't pay their bills or anything without the financial power of attorney. The will may or may not be that critical. Like I said, you'll have probate, but everybody should have a will. And as we'll talk about, if you have, say, adult children and they have children of their own, one of the purposes of the will is to appoint a guardian for those children. And so every adult should have those 3 documents. And if you have adult kids who maybe haven't done this yet, we have kind of a starter program to get them basic documents in place at a very low cost, help them design it and get them executed, because we think it's important that every adult should have these. Above and beyond those 3, absolute minimum documents are revocable living trusts and then potentially irrevocable trusts. So we'll go into a little more detail about each of these. So what does a will do? As I just mentioned, one of the biggies is if you have minor children, this is where you name the guardian. This is where you name who do you want to take care of your kids should something happen to you. So critical to have that. Otherwise, the state's going to appoint a guardian, and it may be a court-appointed guardian. So, You want to have a will that names your guardian. It also appoints who you want to be executor of the estate to administer it. And then finally, it spells out your asset distribution. So if there's no living trust, or there's no beneficiary designations, then that part of the funnel is going to go through the probate process, and your will specify who you want to get what. And do you want to create a trust at death and retain the assets in the trust? Do you want everything to just go outright, like equal to the kids? You designate through your will what you want to happen. If we use a living trust, then really the only purpose of the will, aside from naming guardians for minor kids, is to essentially say, hey, whatever I haven't already put in my trust just goes into my trust when I pass away. So the trust becomes the funnel. Everything goes in there. So a will is super basic. It doesn't have to be fancy. You don't need to have an attorney draft a will. We frequently use a service called Encore Estate, which is similar to LegalZoom, where we help design it. We help fill out all the information, and then the attorneys at Encore Estate draft the document, so at least we can get something in place. So it doesn't need to be fancy. We just have to have something that's properly executed, which means 2 witnesses. Okay, so let's talk about the probate process, because the will go through probate. So the executor is going to file documents with the county of the deceased person. You normally are going to use an attorney to do this. Now, there are some do-it-yourself type of websites and things that are cropping up that may be okay if it's a super simplified process. Generally, you're going to get an attorney to help you through the probate process. There is something called a small estate affidavit. So if all of the assets that are going to be probated total less than $185,000, essentially, you can simplify the whole process. There's a form you fill out. It's like, hey, I'm the sole beneficiary. The assets are just below this number, and you can have a simplified process. If we have to go through the whole process, then you're going to pay probate fees, and that's kind of split between 2 parties. So it's the executor of the estate, and it's also the probate attorney. And so I serve as a professional fiduciary. I'm serving as a special administrator on a probate right now down in Chula Vista, where the client passed away without a will. So I was appointed as a special administrator. All they essentially had was a home and two or three really old automobiles. It's still costing the estate $32,000 in probate fees. So this is one of the reasons you always hear people touting revocable trusts and things like that, is to avoid these costs. If you have to go through probate, you go through probate. This one I was just talking about, I have hopefully a final court appearance next Thursday down in San Diego. I've literally been working on this since June of 23. And so, it takes forever to get these things filed and get court approved and all that kind of stuff. So ideally, we avoid the probate process if we can. So the other duties of the executor: they pay all the creditors, they file the tax returns. Then once the probate's been approved, then the executor distributes all the assets through the terms of the will. They typically can also execute the non-probate stuff, like filing life insurance claims, retirement plan claims, all that kind of stuff. Then they file a final report, and the probate gets closed. So, as I mentioned, it's expensive, and it's time consuming, and it's pretty complicated. It's very difficult to do it without at least a probate attorney involved. Okay, now, let's say you don't have a will. Then you die intestate. And that's exactly what happened with this client where I'm serving as a special administrator. He passed away. He had a wife, and then there were 4 children, 2 with the wife, 2 children of just the husband. And so because he didn't have a will, the state determines who's going to get what. So each state has a different ordering system. California is fairly standard. So it's like, if you have a spouse but no children, the spouse inherits. If you have a spouse and children, for this particular one, it's 1/3 is going to the spouse. The other 2/3 are going to be split up between the 4 kids. If there's no spouse, it goes to the kids. If there's no spouse or kids, it goes to the parents, etc. Finally, you get down to the situation where if there's no relatives at all, then it goes to the state. And I've had that happen before as well. Single gentleman, did not have any remaining family, kept trying to get him to do estate planning. He said, what do I care? I'm going to be deceased. Well, sure enough, he passed away, and his IRA didn't have a beneficiary, and it went to the state of California. We were talking well over $100,000 that he could have, had he just named a beneficiary for it. It could have gone to friends or a charity or anything else. So really important to, at a minimum, have that will, and to avoid both probate and intestacy. Let me just do a quick check-in again. How everybody see the slides okay and hear everything okay? All right, great. Let me see here. Okay. So, also, I'm happy to take as many questions as you like. We'll just do that at the end of the presentation. Again, because the way this webinar system's working, all I can see is my slides. I can't see all the chats or anything. So we'll just do that at the end of the presentation. So now let's talk about the living trust. And I'm sure you've heard these promoted. There you see ads in the paper, you see ads on TV, ads on the internet about setting up a living trust. And so the living trust essentially acts as that funnel. And it's an alternative to the will. And so essentially you create this living trust, and while you're alive, it's revocable. You can revoke it, you can amend it, you can alter it, you can change it, you can do anything you want. It's called an inter vivos or living trust because you create it while you're alive. So it's totally flexible and changeable. So essentially, rather than having an executor like you do with a will, you have a trustee of the trust. The trust document spells out who's going to get what, when are they going to get it, how income's distributed, all of those kind of things. So it's going to say, hey, I want the trust assets to pass down to my 2 children equally. If one of them predeceases, I want it to go down to their children. I don't want them to receive the money until maybe a third at 25, a third at 30, a third at 35, things like that. So the trust document spells all that out. It spells who the successor trustees are going to be. It spells out when the trust is going to end, how expenses can be paid, and all of that kind of stuff. So most states have what's called a rule against perpetuities, meaning that the trust can only last about 100 years, which is still a really long time. If you want it to last longer, for estate planning purposes or estate tax purposes or whatever, there are several states that don't have that rule against perpetuities. So, if we're going to do sophisticated estate planning, we may set up the trust in Wyoming or Alaska or Delaware or someplace else, to make it last longer. But as I mentioned, the trust is revocable, and so you can change it at any time. We have clients come in all the time. It's like the trust is outdated. Maybe the trustee was a parent who's passed away. We can amend the trust. It's as simple as typing up a Word document with the changes and getting it notarized, so there's no question about who made the change. Okay. So, benefits of a living trust. Yeah, it avoids those probate costs. So, if you had $1 million in a trust versus $1 million in a will, you're not going to have to pay the $46,000 of probate fees. There's also no requirement to immediately distribute the assets. Normally with the will, the estate gets settled and everything goes out. With the living trust, like I said, the money can stay in there for as long as the trust is allowed to stay in place. 100 years. And where that comes into play is, maybe you have, say, two children, one of them totally responsible, and it's like, okay, they could inherit several $100,000 in one shot. I don't worry about them spending it. You may have another child who maybe they have, creditor issues, or they have bad habits like, substance abuse or gambling or whatever. Or a lot of times you may love that child and feel they're responsible, but you're not so sure about their spouse. And so the last thing you want is to have this child inherit several $100,000, immediately stick it in the joint account, and then lose it in divorce. And so that's one of the benefits of living trust is, as long as the money is in the trust, you can protect against these things like bad habits and bankruptcies and divorce. So the money can still be used for the benefit of that beneficiary. They can receive income. They can receive distributions of principal for things like buying a home or starting a business or going to college. Or you can just leave it to the absolute discretion of the trustee. So you can provide those protections. Also, where this really comes into play are things like second marriages. You want to make sure that something you have, from your first marriage that had children, that money passes down to them and doesn't go to the new husband or wife of the surviving spouse. So the trust can control those kind of dispositions. It can provide for the surviving spouse, but not ultimately have them receive everything outright. Or if you have special needs beneficiaries, you can provide all kinds of support and care and things like that in a trust while still being eligible for social benefits, etc. So as I mentioned, the living trust, you can control the ultimate disposition of everything, the timing of it. They're flexible. They're easy to amend or revoke. As I mentioned, you don't need to go to an attorney to do an amendment. The key is to properly word it and then have it notarized so there's no question about who made the change. Because a living trust generally is not going to go to the courts. It's the trustee has got to notify the beneficiaries, but then they just have to follow the trust document. And so, the amendment is essentially just a guideline for the successor trustees so they know what they can and can't do. They're also not public. I mean, a big deal can be made out of that is like when you have a probate, there's public notifications and things like that. One thing that's important is if you set up a living trust, and again, it's not a big deal now, it was several years ago, it does not eliminate estate taxes because you essentially can cancel the trust at any time. It's like your alter ego. I mean, so it's not saving on estate taxes or anything like that. But, the will is going to be easier to do and, it's going to cost you less. But down the road, it's going to cost you more because you're going to have probate and all of that kind of stuff. And it's certainly going to cost you more time. The living trust, yes, you're going to pay more now. And again, if we can use a service like Encore Estate, it's extremely low cost. And most of our clients, as part of their financial planning fee, getting those documents in place is included. If it's very complicated, like maybe it is a second marriage or you have special needs or potentially estate tax consequences, then yeah, you're going to have to go to an attorney and spend a couple grand or more, to get a trust drafted. Again, we can help you design everything. So you just go to the attorney so they have to draft it and you don't have to have them bill you for coming up with the ideas. So it's less time and cost later, and that can be significant. It avoids probate. You can include incapacity provisions. So if everything's in the trust, then, one of the spouses passes away or becomes incapacitated, you have the trustee who just steps in and everything keeps humming along. As I mentioned, you can provide all those bankruptcy and creditor protections, etc. Okay, so let's talk about the terms of the living trust. So you have what are sometimes called the grantor, the creator, the settlor. That's the person or persons who's going to create the trust. I typically call them grantors. It's just what I've been used to. So you create the trust. The trust document names who is trustee. So again, if it's a married couple, It's husband and wife as the current trustees. One passes away, the surviving spouse is the trustee. Both pass away, then you name a successor trustee who takes over. And maybe it's not passing away; it's maybe they become incapacitated, um, through dementia or something like that. The trust also names who the beneficiaries are. So children, grandchildren, charities, siblings, whomever you want, and you dictate what the powers of the trustee are. They can, buy rental properties, they can sell stocks and bonds, they can buy crypto, whatever powers you want to give that trustee. Uh, then again, you name what happens at the first death. So commonly, if it's a married couple, it's what we call the I love you trust, meaning surviving one spouse passes away, surviving spouse gets everything. Maybe not in the case of, say, a second marriage or something like that. There may be different stipulations there. And then how income is distributed. So while the grantors are alive, as I mentioned, it's their alter ego. They can take anything out of the trust at any time they want, no tax consequences. But once the trust becomes irrevocable because they both passed away, then you can stipulate, okay, I want the beneficiaries to just receive income, or you can have various terms like I want them to get 1/3 of the principal at 25, a third at 30, a third at 35. You can put sub-trusts in there where, maybe you have minor grandkids who are going to receive some of the money. It can go into a sub-trust and stay in there until age 18 or whatever ages you want. If we're worried about that creditor divorce protection, a lot of times then you're going to leave it to the discretion of the trustee as to whether they want to make distributions or not. So, if a beneficiary is asking for money, but the trustee, you know, expects that they're going to just go ahead and gamble it away, the trustee does not have to make that discretion. Uh, and then you can, like I said, you can have certain purposes, what we call incentive trust. So, the money's held in trust at the trustee's discretion. However, the trustee can make payments for, they graduate college or they want to start a business or something like that. And then you can, specify specific assets. Like maybe you have a collector car or jewelry or something. You want that to go to certain people. You can put those kind of provisions in the trust. So extremely flexible, extremely broad. When we're designing these are all the kinds of things we have to think through. Okay. Who do you want to be successor trustee? When do you want your beneficiaries to get the money? At what ages, in lump sums or doled out, all of that kind of stuff. So those are the things that have to be fleshed out before we can get the trust drafted. Okay, so let's talk about the role of the trustee. I mentioned the executor. The role of a trustee is extremely the same, except you don't go through the probate process. So the role of the trustee is to administer the terms of the trust, to collect and disperse all the assets. So that's that funnel. Everything's going in there. The life insurance proceeds, maybe the sale of the house, the brokerage accounts, all of that stuff are going in. All of the outstanding creditors are going to be paid off. Debts are going to be paid off. Final expenses, all of that kind of stuff. The trustee does have to act in the best interest of the beneficiary. They're going to prepare accountings to let them know what's going on. They have to be informed. And if the trustee is not following the terms of the trust, the beneficiaries can sue the trustee for breach of fiduciary duty. The trustee is going to file the trust tax return, and they're going to protect the assets. And so, if it's a home that's now vacant, they've got to make sure that home is insured, it's locked up, all of that kind of stuff. So it's an important role, and it can be a big job. So who should be the trustee? Because this is always one of the questions we get. So as I mentioned, the grantors are the trustees while they're alive, but then ultimately you're going to have successor trustees. I'd say the majority of the time, you're going to assign a responsible family member, typically one of your children. But they have to be willing and able to serve in that role, and they have to be financially, responsible. It's a big job, to get property ready for sale and to file claims and pay off creditors and all that kind of stuff. And I serve as a professional trustee, and I've had trusts that were open for 2.5, 3 years while we're settling fire losses and getting the house ready to sell and things like that. And then the biggie is they've got to follow the terms of the trust. They have a fiduciary responsibility to the beneficiaries. And so particularly if whoever is selected is also a beneficiary, they're exposing themselves to liability if they don't follow everything to a T. Because if the other beneficiaries think that, hey, this person's not really acting in my best interest, the trustee can be sued for breach of fiduciary responsibility. So if you don't use a family member because maybe you just don't have one, or you don't think they're up to the job, or they wouldn't want to do the job, then a lot of times you hire a professional fiduciary like our firm. So there are private professional fiduciaries who are in the state of California. They have to be licensed, and they have to be credentialed. And so the idea there is this is what they do on a daily basis. It's part of their business. So they're impartial. They're going to follow the trust rules. They're experienced with processing probate and trusts and all of that kind of stuff. They can also serve long term. So if you want to leave the money in trust to protect it for creditors and all that kind of stuff, you're probably going to want a professional fiduciary who can be around for many, many years to serve in that role. And again, you're still going to name successor private fiduciaries because companies, can change or go out of business. So Anchor Bay, myself, and one of our other planners, Blake Pinion, we are licensed as professional fiduciaries. We can serve in that role as a trustee, executor, all of that kind of stuff. So in situations where you want someone who's going to be impartial, maybe there's family conflicts, or you just don't have somebody who's up to the role, something like that, you may want to consider a private professional fiduciary. Okay, so now what do you put into the living trust? So the biggie is typically your home. So once the trust is created, one of the documents that gets executed is a deed transfer. So your home is retitled from your, John and Mary Jones joint tenants with right of survivorship to the John and Mary Jones revocable trust dated whatever the date is. If you own other real estate, you're going to transfer your other real estate in there. One that gets missed quite a bit is your bank accounts. So you may have joint tenants with right of survivorship on your bank account, but God forbid something happens to both of you at the same time, it's now subject to probate. So you want to retitle your bank accounts in the name of your trust. Bank accounts don't change. The only thing you have to do is if you're still writing checks, you have to get new checks with the name of the trust on them. All your individual investments. So like if you have a brokerage account, with us at Charles Schwab or whatever, we're going to retitle that into the name of your trust. So then we don't have to worry about probate. When you pass away, whoever you've named as successor just steps into that role. They can continue to manage that account with, no delay or hiccups or anything else. And then when the trust is executed, one of the documents is also a property transfer. So, there are lots of things you have that don't have titles to them. Jewelry, art, collectibles, all that kind of stuff. So you have a kind of a generic property transfer document that says, hey, I'm transferring all of my stuff into my living trust. And so, we don't have to do any extra paperwork. It's just transferred. If you own a business, an LLC or corporation or whatever, you may want to transfer your share of the business interest into the trust. So pretty much anything that could potentially be subject to probate is going to go into the living trust and be retitled. What doesn't go into the living trust are things you can't transfer. For example, your retirement plans, your 401k and your IRAs, you cannot transfer those to the living trust. The living trust can't own them. They're non-assignable. So you name the beneficiary, and it could be that the beneficiary is the trust, and so the trust becomes the funnel. Same with life insurance. There are situations where we would transfer ownership of the life insurance into a trust if we're worried about estate tax, but generally, you're just going to name the trust as the beneficiary of the life insurance. And then annuities, very much like 401ks and IRAs, are non-assignable. So those pass by beneficiary designation. They may or may not go into the trust at death, and I've got a slide on how that would work in a sec. Okay, so do you need one? I would say most people generally need one. Again, when, if we're using our Encore Estate service, it's extremely inexpensive, or it's even included in your fee. If we have to go to an attorney, you're looking at probably in the $3,000 range. But again, you're not generally going to an attorney unless you've got a complicated situation. So does it avoid probate? Yes, absolutely it does. And like I said, that gentleman in Chula Vista had, a trust. He would have saved $46,000 of assets that are going to myself and the probate attorney. It provides far more control and flexibility, and that's really where it becomes important, because for each beneficiary, you could do something different, and so it can protect against those bankruptcies and those divorces. You can hold funds in trust for minors. You can use it to pass on family values, like things like an incentive trust, where you want to start a business or you graduate from college, and then obviously if you have special need family members, the trust is really important. Very important for second marriages and blended families, because you may want to preserve, things for children from a first marriage, etc. It's super easy to change and amend. And yeah, even if you have to go to an attorney and spend $3,000 today is much better than $46,000 at death. And if we have estate or inheritance taxes, then the living trust becomes more important. My general recommendation would be, if you own assets, you should probably have a living trust. They're not that expensive. They're easy to do. They're flexible. And yeah, you should do it. So let's talk about the other estate documents. And again, these are the ones that everybody should have besides the will. So the first one's your financial power of attorney. This allows for someone to transact your finances if you become incapacitated. So you've had a stroke, you have dementia or Alzheimer's, or you're in a coma, etc. So the power of attorney allows whoever you name to pay your bills, to deposit and withdraw funds, to change investments, transact legal documents, to care for pets, all of that kind of stuff. And so, you have a financial power of attorney, and you need to deposit money in a bank. You can go in and do that at the bank. Generally, financial institutions are going to want to have a copy of the power of attorney on file. And there are some financial institutions that may say, we're not going to take the one the attorney's drafted, we want our own. And so, sometimes they can put up some roadblocks. Now, the financial power of attorney does not impact assets that are in a trust. If it's in a trust, the trustee essentially serves as the financial power of attorney. But the financial power of attorney is still required, because there are things you can't put in a trust. For example, say you have a 401k and you're incapacitated. The trustee can't do anything with that 401k because it's not in the trust. The financial power holder would still have to do that. And there's two versions. A durable means it's effective immediately and it stays in place. Generally, if it's a married couple, it's a durable power for both of the spouses. And then the second kind is what's called a springing power of attorney. So this does not become effective until at least two medical professionals have diagnosed the person as being incapacitated. So this typically would come into play, if you're going to have a child step into that role or something like that. Usually that's not going to happen until you've been deemed incapacitated. Now, there are situations where maybe you're not incapacitated, but you're elderly. You're in your 90s. You may want to have, say, a child serve as that financial power of attorney, simply because you're just maybe not up to handling your expenses anymore. So financial power of attorney. The next one's the healthcare power of attorney, and what's also called the living will. So this is where you're going to dictate what you want in terms of healthcare decisions. So again, like the financial power of attorney, you can't make these decisions. You're in a coma, you're terminally ill, etc. So you're going to dictate in the living will, do you or do you not want life support? Do you want feeding tubes? Do you want pain relief? All of that kind of stuff. Do you want to be an organ donor? And is it for only certain body parts? Is it only for, say, transplant or therapy? You don't want to be a cadaver. Uh, do you consent to a voluntary autopsy? All of that kind of stuff. And then you name, like you do for the financial power holder, you name someone who can make these decisions for you. But the benefit of the living will is it's specifying what you want. So then whoever you're naming doesn't have to agonize over those decisions. So they know what you want, and so then they can make those decisions for you when you can't. So again, at a minimum, every adult should have these documents. The other part of the living will and healthcare power of attorney that's now required is what's called a HIPAA form. So, again, say one of your children's in the hospital, uh, having surgery or whatever without a HIPAA form, generally, the medical professionals are not going to talk to you. And so a HIPAA form is also one of the documents that comes along with the healthcare power of attorney. Okay, so now let's talk about beneficiary designations. I talked quite a bit about that. Annuities, life insurance, 401ks, all of that have beneficiary designations. So the general rule is if you're married, we're normally going to name your spouse as the primary for both life insurance and retirement plans. The reason we want to do that for retirement plans is when one spouse passes away, the other spouse can essentially roll that into his or her own IRA. And then they can take distributions, as required at 73, etc. There is one exception to that is, let's say we have a surviving spouse that's only 55 years old, and we're going to need that money to live off of. If they roll it into their own IRA and then they take the money out, that 59.5 rule applies and they need to be subject to the 10% penalty. However, if they don't roll it and they take it as an inherited IRA and they take it out at 55, the 10% penalty does not apply because death is one of the exceptions. So there are situations where we won't automatically roll it over to a spousal IRA. We have to evaluate, are we going to need some of these funds prior to 59.5, et cetera. Now, single individuals need to evaluate, do we want it to go into our trust or do we want it to go to certain individuals based on the circumstance? So, a little more thought has to go into it with a single individual. What's really critical here, and it's part of our estate planning process, is that beneficiary designation controls. You could have a will, you could have a trust, but if you have an out-of-date beneficiary designation, that's going to control. I don't know how many times I've seen, say, a life insurance policy that has a spouse from 2 marriages ago still named as the beneficiary. That person passed away, that spouse is going to get those death benefits. The beneficiary designation controls over any other document. So really important to make sure that we keep our beneficiary designations up to date. We create a living trust. We're going to transfer all those assets in there. The next step is we're going to name the trust as a beneficiary of the life insurance and the retirement plans, et cetera. Otherwise, they're not going into the trust. Okay, so let's talk a little bit about life insurance. It can be, again, it depends on age and financial status and everything. It can be an important part of the estate plan. So some of the benefits of life insurance, it pays income tax free to the beneficiary at death. So you don't get to deduct premiums going into life insurance because it is income tax free at death. As I mentioned, the beneficiary designation controls. And so you may or may not need life insurance. Again, it depends on your station in life and your other assets and all that. But sometimes we may want to use life insurance to replace lost income, to offset, say, if one spouse is on a pension or their Social Security benefits, they pass away, that pensions could potentially stop. Social Security benefits will go away. Maybe we need to replace those with some life insurance. Maybe we want to pay off a home, that still has a mortgage. Maybe we want to fund college if we have younger kids. I would say the vast majority of the time, we're just using term insurance for this. Inexpensive, low cost, cheap term insurance. Sometimes we may look at permanent insurance if it's a long-term need or something like that. In general, we're going to analyze, A, do you need any at all? And I would say oftentimes you don't, unless maybe you're younger. B, if you already have it, do you need it, or is it the best life insurance? And then C, like how much longer do you need the life insurance? And then make sure the beneficiaries are up to date. So now let's shift gears again and let's kind of talk about some of the common estate planning mistakes. The biggest, not having a plan in place. We get a lot of clients coming in that just haven't dealt with this. And as I mentioned before, it could be that maybe if it's a married couple, they're not on the same page as to what they want to do. Maybe they just don't want to incur the costs. Lots of reasons that people don't deal with. Nobody wants to deal with, the issue of death. So I would say it's pretty frequent that people come in without having a plan in place. In fact, 6 out of 10 Americans don't have an estate plan. So that's a biggie. So they may have a plan in place, but they don't have the actual the documents, or the documents are old and they're out of date. Maybe there's successor trustees who have passed away or too old to do it. Maybe they were drafted prior to these major estate tax law changes, and they still have all these estate tax savings things that are not applicable anymore. Again, no, or not enough life insurance. It's something we model to see if you need it. And not having an elder care plan in place. So, this is part of the estate plan. It's like, okay, what happens if, you need additional care? Are you going to have home health care? Are you going to move into assisted living? Are you going to have to move into, memory care? How are we going to fund those costs? What are we going to do with the home? All of that kind of stuff. And then, as I mentioned before, like selling assets right before death. I've seen this quite a bit. Mom and dad are going into the nursing home, so we're going to sell the house, and they're 94 years old, and if we had just waited until the first spouse passed away, we could have avoided a bunch of capital gains tax at potentially 33.8%, between the federal and California. So those are some of the common mistakes. Some additionals: you took the time and the expense to create a living trust, but then you didn't transfer anything into it. Happens all the time. I already talked about outdated documents and then outdated beneficiaries. As I mentioned, we see it quite a bit. You get divorced, you get remarried, you don't update your beneficiary. Or we have deceased beneficiaries, and if that's the case, then it just becomes part of your estate and it goes into probate. And then the final one is, anymore, everybody should have digital documents. Before, if you put your will and trust and all that in your safe deposit box, when you pass away, that self deposit box gets frozen if you're a single individual, and you can't get in there. So if you want to have paper documents, you want to put a copy in the safe deposit box, fine, but you should have paper copies somewhere else that someone knows where it's at. And ideally, we have digital documents now that can be accessed. Okay, so let's talk about some of the smart things you can do. Review the documents and beneficiaries every year. We just do this as part of our financial planning process. Generally, our year-end reviews, we're looking to make sure everything's still up to date. As I just mentioned, store documents digitally. So every time we get documents executed for a client, we're scanning them, we're storing them in their vault in their financial plan. So God forbid something happens, their trustee or children, whoever, can just contact us. We've got all the information and we can guide them through the process. Also have up-to-date asset and liability lists. So someone, knows where everything is. What are the credit cards that are going to have to be paid off? What are the assets? Where are the retirement plans? All of that. In addition, it's, the digital asset logins. So, being able to go in and turn off all the social media. If you have cryptocurrency, it's critical that someone has, the keys so they can get into those things. And this one's kind of a difficult one. is to let your heirs know about your plan. So, if you're, from say the greatest generation, you never talked about finances with your children. It's like that stuff was top secret until something happened. I think the baby boomer generation is more open to talking about this stuff with their kids, letting them know this is what I want to do, this is the plan, keeping them up informed. I personally think that's a good way to go. And one of the services we offer, if you want to go that route, is to consider a family meeting where you can have someone, say from our firm, come in and explain this is the plan, this is why we're doing it this way, kind of hopefully mediate any hard feelings, that kind of stuff. And then obviously if you own a business succession planning is part of your estate planning. Like you own a business and something happens to you, what's going to happen to the business? Is it going to fold? Do you have a successor lined up? Is there an estate plan for the business? All of that. And then as I mentioned, the elder care plan needs to be part of the estate plan as well. So just a couple other things, and then we'll open it up for questions. So consider tax planning as part of the estate plan. So there's lots of things we do, keeping an eye on tax savings for, the future. For example, Roth IRA conversions. We do that not only to save taxes in the future for, the current participants, but also those are tax free. And so they're a great legacy asset to leave. And so, we want to do Roth conversions as maybe part of the estate plan. That whole spousal rollover versus an inherited IRA, as I talked about, if you roll over to a spousal IRA, yeah, you don't have to take money up till 73, but let's say you're only 50 and you need the money, you're subject to the 10% penalty. So maybe we would have both a spousal rollover and an inherited IRA. The stretch IRA thing, it's now 10 years, but still we can play around with when do we take the money out of the IRA to maximize, income tax savings for the beneficiary. And then we can do more sophisticated stuff if we need to. For example, there's, gifting. You want to make gifts to your kids, help them buy a house or whatever it is. We talk about the annual exclusion gift. Or if you're making very large gifts, we can help you, file the gift tax return and all that. We'll also use a strategy called an upstream gift. I've used this a few times. An example here was had a client who had super highly appreciated stock, to the tune of several $100,000 of capital gains. His mom was 93 years old, in pretty good health. So what we did is we gave her some of the shares of the stock. So she owned them. She got the dividend from the stock, but we made the client the beneficiary of that stock. So when she passed away, it got that stepped up cost basis. So all of that capital gains tax went away. He re-inherited the stock, and we washed away the tax. It's a strategy that fits in certain circumstances, but we can look at gifting both upstream and downstream. If we're worried about estate taxes, then we can do things like life insurance trusts and other estate reduction strategies. We know that stuff inside and out. We don't have a ton of clients who need it, but we have it. And then finally, charitable giving and philanthropy. What do you want to leave to charity at death? And so there's some things you can do with charitable giving. You can just give it away while alive. So you can give away, say, shares of appreciated stock. You can do all kinds of things like charitable remainder trust, charitable lead trust, and donor advised funds, and all of that kind of stuff while alive. So there's lots of strategies you can use. Or you can give it away at death. Like, you can set up various types of charitable trusts at death, take advantage of both estate and income tax savings. And then, you can bequest IRA or other assets to death at death. And so there's planning that can be done here too. What we normally say is to give the bad assets to charity and give the good assets to the kids. So here's an example. Let's say John has two assets. He's got an IRA worth $100,000. He's got a stock portfolio worth $100,000. So his plan is to leave half to charity and half to kids. So this would typically be a situation where, if there's no planning done, the kids are named the beneficiary of the IRA. Charity inherits the stock through the will. What happens in that scenario? Well, as I mentioned, earlier when we talked about income taxes, because John's never paid tax on that IRA, the kids get to pay the tax. So the kids cash out that $100,000 IRA. They have income in respect of a decedent. So let's assume it's a 30% combined federal and state income tax rate. The kids net 70, Uncle Sam inherits 30. Now the stock got a stepped up cost basis at death, but also charity's tax exempt. So charity inherits the 100,000. So, in this scenario, we essentially only really passed 170,000 of the 200,000 because we did not do proper planning. If we had simply switched who the recipients are of the assets, for example, if the kids inherit the stock rather than the IRA, stepped up cost basis, they net $100,000. Charity inherits the IRA, they're tax exempt. They don't pay the tax, so they net $100,000. So we essentially, netted all 200,000 to who we wanted it to go to, and we disinherited Uncle Sam. And all we did was retitle which asset which went to which entity. So there's lots of types of planning that we can do in the estate plan to maximize tax savings. So kind of to wrap up before we take questions, how can we help you through all of this? Probably the biggest is to coordinate and develop the estate plan. If you don't have a plan or you've got an outdated plan, we can help you design it. If you need documents, as I mentioned, we have this online service called Encore Estate, where we're not playing attorney. The attorneys at Encore Estate draft the documents, but we design it all, and then they draft the documents, they send them back to us, and we help get them executed. If you need to go to an attorney, we can refer you to an attorney. So we help with estate plan implementation, design, review. As I mentioned, we serve as professional fiduciary. So if you don't have someone that you're comfortable with serving as the trustee or the executor or the financial power holder or whatever, we can serve those purposes. We're properly licensed and credentialed to do that. Even if you're going to have, say, a child serve as the trustee and executor, they probably need help. So we can help them with estate administration, getting tax ID numbers, filing all the appropriate returns, doing the accounting, all that kind of stuff. We can prepare all of the estate, gift, trust, individual tax returns that are needed. As I mentioned, when you have documents, if you're doing financial planning with us, we're going to have digital copies of those documents stored in your vault. So if God forbid something happens, we can help walk your heirs through the whole process. And then finally, if you want to have those discussions with your family, we're more than happy to essentially conduct those family estate meetings for you. And then finally, as needed, we do have extremely deep estate and charitable tax planning expertise. As I mentioned, I spent 20 years of my career manage a team of 23 CPAs and tax attorneys, where that's all we did was help millionaires and billionaires figure out how to save millions of dollars of estate tax. Not the most meaningful work. I much prefer to help a client retire or pass their estate down to the heirs properly rather than focus on estate taxes. But we do have that expertise if your situation warrants it. So with that, I'm going to go ahead and open it up for questions. Let me see here. Okay, so if you have questions, you can go ahead and put them in the chat feature. Okay. Oh, looks like we had some issues with the share. Okay. Oh, I apologize. It looks like some people had trouble seeing the slides. Well, it will be recorded, or it is being recorded, and so we will post it and let you know when it's available for watching. I apologize if some of you could not see the presentation. So last chance for any other questions. And if you do have them, you want to talk about it, just give myself or Blake or Rob on the team a call, and we're happy to discuss your situation with you. Um, and again, we'll have this posted probably sometime next week. We'll send you an email letting you know it's available for viewing. So hope everybody has a great rest of the evening, and we will talk to you soon. Good night.